Thank you for coming at very short notice. We decided to speak with you this afternoon following the announcement by the Speaker on the issue of the confidence motion and what he had promised at the last time we met, that he will deal with the consequences of the vote. I have here with me Vice President Kamraj Ramjatan and Minister of State Joseph Harmon, and we have decided that we will come to you together because the issue is where has this announcement taken us? It is very, very clear that the announcement by the Speaker has opened the door for a judicial challenge to the vote as had taken place on the 21st of December. The Speaker has clearly stated that there are some very strong and compelling arguments based on legal practices and precedent in other jurisdictions, other countries, that would require that this matter of the vote be examined by what he described as a court of competent jurisdiction. In other words, one of our courts must decide whether the number of votes cast for the respective side in that episode meets the requirement of the Constitution. And he said that while he could has the power to revisit and even to reverse a ruling, he would do so only if there are compelling reasons. And if a court adjudicates that the majority, as we had seen on that occasion, did not meet the requirement or the threshold of the Constitution. So in the view of the government, this is a significant development because it means that we continue as a government. The Speaker has been very deliberate in pointing out the article of the Constitution 1067 that says the government continues in office and would do such things as are necessary as a government until new elections are held and a new president is sworn in. And as you can see, given effect to that, just now in the Parliament, National Assembly, several bills were proposed with far-reaching effect to bring improvements to the lives of the Guyanese people and to bring services to them that would be beneficial. And so the Parliament continues to meet. As you know, on the last occasion, the Speaker said that the Parliament was adjourned until the 3rd of January, and he would make these announcements as he did today. And therefore, it was with some surprise that we saw in the press that the opposition said that the sitting is unconstitutional and there should be no meeting of the Parliament. Well, that was announced on the last occasion, and the Speaker did, in fact, follow up on his commitment to give the parameters of what he considered to be the consequences of the decision. So I will ask my colleagues, first with Vice President Ramjatan, to pronounce on his interpretation of what happened.
Thank you very much, Mr. Prime Minister. I just want to state that I think that in the Speaker's view, his uncertainty as to the number of members which constitute, quote, a vote of the majority of all the elected members of the National Assembly, namely whether it is 34 or 33, has caused his moving towards a judicial interpretation. It is quite clear. Now, there are some benefits about that. Such a judicial interpretation will bring finality to the matter for all and sundry. What is clear also is that in the meantime, from what the Speaker ruled, Article 106(7) must apply because there has not been a resignation of the President nor the government. Neither will there ever be a resignation of the President or the government. Article 106(7) is pellucid, that the government of the day shall remain in office for 3 months or such longer period as the National Assembly shall by resolution, supported by not less than 2/3 of the votes of all the elected members of the Assembly, and shall resign only after the new President takes the oath on the following elections. Now, during this time, and this is my very important point to you, the government remains in office. It is entitled to exercise its functions. The country cannot be left without any government at all. A governance vacuum is never permitted. The government retains its full panoply of legal powers, whether that be statutory, prerogative, or common law, and is with jurisdiction to exercise its legal authority. The House, as you know, recently passed, and very fortunately, the 2019 budget. And of course, it is expected that expenditures approved therein are going to be strictly adhered to. Because indeed, we have passed the budget.
Affirmation of the motor vehicles and road traffic amendment.
Yeah.
So you have to go.
Oh my goodness.
Okay, just let me take up where Vice President Ramjatan left off. And that is that Article 106(7), the Speaker did indicate that this is an opportunity for the government and the opposition to have dialogue on issues. I want to say to you that this morning, the President instructed, and based on those instructions, I wrote the Leader of the Opposition, inviting him to a meeting on the 9th of January at 11 o'clock at the Ministry of the Presidency. Since this was a meeting which the Leader of the Opposition requested, then I requested of him to indicate what are the matters to be placed on the agenda for such a meeting. So we will await that information from him. So in fact, we have actually taken an active step in this regard. But more importantly, it is, in my view, the posturing of the opposition that is important here, that seems to want to create this level of uncertainty in this country. And this is something that, as citizens, we have to guard against. The opposition said that they consider this sitting of the National Assembly to be illegal. But yet, when we came to the Assembly this afternoon, there was a letter from the opposition chief whip requesting of the Speaker for the opposition not to attend the session this afternoon, which was granted by the Speaker. So you can't consider it to be illegal and still agree to subscribe to his jurisdiction by asking permission to stay away. So these are things that the Guyanese citizens must be aware of, these grandstanding by the opposition. It is also very clear that the Speaker alluded to Article 153 of the Constitution as against about the member voting against a list. And these are all issues apart from the question of whether 33 constitutes a vote of majority on a no confidence motion or 34. Since that is an area which requires clarification, I believe what the Speaker has also put in the mix is the question of a member voting against his list. So I believe that all of these are issues which cries out for a clarification and interpretation to be given by a court of competent jurisdiction. And we believe, as we have said, we respect the Constitution, we respect the ruling of the National Assembly, we respect the ruling of the courts, and therefore we will use all of these means that are at our availability, at our disposal, to ensure that we bring clarity to this situation. As the Speaker said, this has never happened before in Guyana. And so what we need to do is to also set a precedent, a very clear precedent, as to how matters of this nature will be dealt with in the future. So that's what I want to say.
Do we have any questions? Go ahead.
When the Jeffrey Channel 2 headline news, kind of, with the Speaker upholding his ruling of the passage of the no confidence motion.
No, the Speaker has not used the word upheld. He declined to reverse the
Okay, so the motion stands, the ruling stands. What he ruled on the 21st stands.
Well, in effect, but he has said that he has doubts, and I will quote what he said so you don't put him in a context that he doesn't deserve. I have received from diverse sources information, both solicited and unsolicited, supported by case law and practice emanating from other jurisdictions, which has raised doubts as to whether the no confidence motion was carried, and properly so, by the margin of vote. So here is a speaker who says that from what he has seen, he has doubts as to whether this motion was carried. So, but he went on to say that the speaker has the authority to reverse it, his ruling, but he would not do so unless there are compelling reasons, and he would prefer that the matter be pronounced on by a court, because the court is the organ that interprets the Constitution. And I think out of an abundance of caution, the Speaker is saying, look, I could do this. I could reverse this ruling, but wouldn't it be better if the courts were to deal with this issue? Someone approached the court with an application to interpret what is meant by majority, for example. And then the court gives a pronouncement, and usually, and what has to happen is the Speaker would then obey the court. So what we have here is a situation that doesn't say that the Speaker has reaffirmed the ruling. He says he has doubts, and he has been receiving all these authorities around the world that would tell him that perhaps that there is a good merit for the argument that 34 constitutes a majority. Just now I was looking at a case, a situation in Pakistan, which is a Commonwealth country. And Pakistan has a system where the Prime Minister is appointed by a majority vote. And in their parliament, the vote turns out to be 2 more than the next candidate because of their formula. So they're arguing that if that applies in Guyana, it will be 1/2 plus 1. But if you have 1/2 of a fraction, and you have a fraction, you have to round it up. And when it is rounded up, then it produces the majority. So there are cases in many countries. In Kenya, I've seen another case that was sent to me last night that tells you that there's a similarity of the position, that where you have to deal with fraction, like a parliament with 65 members, you don't have half a member. Therefore, if you have 32.5 as half, you have to round it up to 33 and then add 1 to get at a majority. Therefore, the formula is 1/2 round up plus 1. And they have that in many countries dealing with uneven, odd numbers in parliaments. So here is a case where the Speaker is saying, look, I'm looking at these, all these contentions, the authorities, and I have doubts now in my mind.
Okay.
So That's where it
That
is.
was the preamble to the question I was wanting to ask, which is, is the country heading towards an election in March, given the 3 months, given the fact that the speaker did not undo his ruling? And if it's not heading to an election in March, can the court stay the election, the impending election?
Well, it's actually a hypothetical question based on an if. If you were to go to court, I'm sure part of the application in going to court is to ensure that time doesn't run. That's the acceptable principle until the determination of the matter. So it is possible that a court can say, okay, I'm going to look at your application, and for the time being, the status quo remains until the hearing and determination of the matter. So it is possible. But I cannot say, I'm not the court. I cannot say that the court, as soon as you walk in the court, they said, okay, there shall be no elections. As it is, you have to deal with the Article 106.7 that tells you a different story. Is that the time actually is a time that could be extended, that could be varied once you get into the National Assembly, and with the support of 2/3 majority, you can extend the time to any date you would want to, any further date. So one shouldn't create any kind of feeling of panic or desperation that the time is clicking and something is going to happen. No, the time that is there is the normal time that stipulates on a section of the Constitution that says when a vote of no confidence is passed, then this happens. But if this doesn't happen, if the government doesn't resign, then the government continues until a time as dictated by a motion of the National Assembly. That is why the Parliament has to continue to meet, because the Parliament has to determine what further date. This is not a country where you have, some countries, when a vote of no confidence is passed, you go to the Governor General, and the Governor General can appoint somebody else in who they had confidence in to form the government. Because the government has fallen, they can call on somebody else who controls the majority in the House to form the government, or to have elections within a specified period of time. Guyana doesn't fall in that mold because it has the saving clause of 106.7 that says the government shall continue in office until, based on the motion for the extension of the period. And I think that that's where the Speaker
He started
today, he
yeah.
started on that basis
Yeah.
to look at that article, because I think it's very, very strong article that kicks in at this point in time.
If I might, please, because both of you guys are attorneys and good at your jobs, and we are learning, we the public are learning as we go. The follow-up question is, can the court stay the elections, given the constitutional realities and provisions that only 2/3 of the Parliament can extend the 3 months? Can a court do that?
The court can stay the execution of an action that was taking place in the National Assembly once it has to do with the question of the interpretation of the Constitution. It's not a matter of postponing the elections. It's a matter of dealing with a constitutional matter which has been placed before it. And so if in the interpretation of the court it requires some time to do that, you cannot have a situation in which the order of the court is made nugatory, because it is now given after the fact. And therefore, these are matters which the lawyers will argue in the court. But it's not as if the court is saying, okay, postpone these elections. The court is dealing with an interpretation of an article of the Constitution which has come to it for determination.
But Wendell, let me put it this way. You see, there's this argument out there that the government should resign immediately. You probably heard that as soon as the event took place on the 21st of December, resign right now, hold elections in 90 days. It don't happen that way. The Constitution says, and that's where the Speaker started off by quoting the relevant article of the Constitution. He says, notwithstanding its defeat, the government shall remain in office, and they shall hold an election within 3 months or such long a period as the National Assembly by resolution supported by not less than 2/3 of the votes of all elected members of the National Assembly determine, and shall resign after the President takes the oath of office following the election. So you see, that brings in a new scenario. Not this desperation and say, resign now, pack up your bag and go. No, this tells you that there is a provision for, under which the government continues in office, and that's why we are meeting and we are doing government work, passing bills and legislation and motions and doing public works, etc. So I believe that the ruling today, and that's what we're dealing with, has placed the country in a situation where it can only benefit. That is, you had an election in 2011. The government got 32 seats, it formed a minority government. The opposition 33. 2011, you had a minority government and a majority opposition. You had elections in 2015. You have a majority government and a minority opposition, a 1 seat. Now you have elections down the line. 2020 is constitutionally due. Suppose it produces the same results, 32-33. You're still in a quandary and you're still in a state of uncertainty. So the Speaker himself is saying, I want a Speaker to have a definitive ruling, an interpretation of the Constitution, so that we don't go down back the line. Every elections we have a government in, and 2 months after, 3 months after, 3 years after, you have a change of government. Democracies cannot be fragile. Democracies cannot be unstable. Democracies cannot be uncertain. And what is happening here today, as I said, we have some challenges, but it offers us a tremendous opportunity to revisit our law, our supreme law, our Constitution, and to see with certainty what this Constitution is saying, or else we'll end up in another cycle of instability and weak government, or perhaps a situation where all types of confusions are created, and it opens up to an opportunity that you have elements, interests other than national interests can intervene to buy a government, to buy a vote. In some countries, you have people resort to the use of arms, guns, to remove an elected government. They call that a coup d'etat. Here you have gold is being suggested as the preferred weapon to remove an elected government. So your Constitution has to be the fount of your strength and your stability. And I believe from the government, I speak for the government, that the Speaker has taken a mature, wise, and elevated position to place this matter for an interpretation in the court, so that the court can guide the country as to what these provisions mean. So you can't opportunistically derail the work of a government because you have the money bag that you could buy someone. And of course, the Speaker went so far to say that it raises some problematic. If someone is elected on a party list, chooses to use his vote to support another list, is that permissible? Or where someone is a national of a foreign country, comes into your parliament, swears allegiance to a foreign country, and casts a vote to remove your government, is that permissible for someone with a foreign nationality, or even a dual nationality, to do that? So I believe that the Speaker has quite rightly raised a gamut of important issues, and he has placed them in a very simple and forthright way on the table, informing the Guyanese people that, look, I could reverse this, but I want the court to give me some compelling reason why I should do so. And I'm not going to take this and run with it. And he said here that what he aims that we can have is full, final, and complete settlement of these issues by a court of competent jurisdiction will place beyond doubt any question which may exist and serve to give guidance to the Speaker and to the National Assembly for the future. For the future. So I think that this is a very important ruling. I don't know if my colleague, Minister of State, has anything else.
No, I think that's a very complete treatment of the matter, PM, and I think it is very clear that what the Speaker has actually said this afternoon will redound to the benefit of all Guyanese. And it clarifies a number of issues which are out there. People who are raising these matters, some of them in the diaspora, some of them here in Guyana, all of whom have an interest in the development of this country, and all of whom are interested in the order and good government of this country, and that they are concerned that what is happening here is an attempt to derail the developments that are taking place in this country for the benefit of a few persons whose primary focus is oil and gas. That is all I wish to say, sir. Thank you.
Considering all the developments, I don't think one thing is clear. Are you going to take it to court, and how soon can we see this being filed?
Yes, we are going to take the matter to court, and in fact, our Attorney General has advised that the matter be filed tomorrow morning. Yes. Thank you.
Go ahead.
All right, let's
Age,
take
age.
one more. And then let's go.
Yep.
Yes, can you give some indication of what is likely to be on the agenda of this first meeting between the President and the Leader of the Opposition? And secondly, if you can intend to continue business as normal as a government, aren't you in some kind of moral quandary in that you, as the incumbent, are in a position to, put in place policies and systems that will give you an advantage in the coming election?
Well, look, there are two questions you've asked. The first is about the agenda. I think I addressed that earlier. And that this meeting was at the request of the Leader of the Opposition. And so what I've asked him is what items he wishes to place on the agenda.
You haven't gotten that yet.
No, this was today. So I suspect that during the course of the week, he'd respond and say, well, these are the issues I would like to discuss. And knowing him as I do, you probably will get the agenda before I do.
Yeah. Can you say what items you would like to see?
No, this is a conversation between the Leader of the Opposition and the President. It is not my meeting. I am basically expressing the intentions of His Excellency. He is actually responding to a request for a meeting. And therefore, if you ask for a meeting, at least you should say, look, this is what I want to discuss. So once we get that, we will set an agenda. We will set an agenda, and as is known, we will actually let the country know what it is that we're talking about. Now, secondly, talk about a moral advantage. We have passed a budget in the National Assembly. This afternoon, we passed some of the measures that will put some of these things into effect. And therefore, as a government, it is our obligation to ensure that these programs and projects, as are indicated in our budget, are executed. So it's not a matter of actually trying to get a moral advantage. We have laid out a program in our budget debate. Each and every one of the ministers and the members of parliament spoke extensively as to what they intend to do in the next year. And so what you are going to see happening will be an execution of those plans and those projects which have been identified in the budget. And this is what we can guarantee you: due regularity and spending consistent with our plans and programs that have been laid here in the National Assembly.
Let me add to that. You see, once the judicial process kicks in, then you can't circumvent that. It's not buying an advantage. It's allowing the necessary time, judicial time, to probe and to determine this matter in much the way that the Speaker would want to see a full and complete resolution of this problematic, of this contention, this controversy. It is a legal issue, has to do with constitutional interpretation and some other matters as well. But the crux of the matter is this, is that we are not trying to buy time. We didn't place ourselves in this situation. An opposition came, perhaps without looking at all the ramifications of having someone cross the floor. That's putting it very mildly, you know. Someone crossing the floor to support you hadn't thought about it because they had a legal opinion since 2014 that would have told them that they needed 34 members. And actually, one of the members of the opposition keep telling me that this no confidence motion is a bluff. They're seeing, you know, where the wind is blowing. Well, if you want to see where the wind is going and it blows frog in your face, then you don't have anybody to blame that they're getting an advantage of that situation. You know, you have to take responsibility for your action. So we will patiently await the outcome of the court determination of all the matters here. But I want to add, and this is because of the new year and because of who I am, very generous, that yes, even we may say politically that this was an opportunity that might have turned sour in terms of what happened in the assembly itself, because there are criminal investigations going on right now too, so don't rule that out. And there are other probes that are taking place, all in connection with whether or not the vote had been compromised, whether or not the integrity of the House had been violated. It's very difficult for someone to come into a House and violate the privileges of the House if it is found that the person had been compromised, had been bought or sold. These are things that will come out in investigations, so things are happening. But what I will say here is that in the meantime, even if you thought that this was a frolic, the opposition has bought itself a seat at the head table. Not any part of the table, at the head table. That there are issues that you want to dialogue over, issues that you would want to negotiate, issues that you want to discuss. That's how a responsible opposition would now take this matter forward and not be obsessed with whether or not the government should resign, whether or not they should take over the reins of government tomorrow, whether or not they should hand over the oil assets and our territorial integrity to any friend or friends. These are not a matter they should be obsessed with at this point. They should be very concerned that the country has been brought to a stage where it is important that we tell the Guyanese people that we have peace and good order, and we have stability in our country, that we continue to pursue the development path. We continue to do things that will benefit the Guyanese people. This is what we want to come out of this situation, that, look, can't make it worse. We can't hope that people begin to fight each other in the streets, and can't stoke the fire of ethnicity and racism. We saw that before the motion was debated, where members of the opposition were on social media telling people of a certain ethnicity not to come into the city, that they will be beaten, telling people that their businesses will be burnt down and looted. irrational, irresponsible, criminal statements that a plane had left a very known figure whose name nobody wants to mention in this country. No sane person mentions his name anymore. Says how a plane left Oakley Airport full of gold and foreign currency, creating mischief, spreading deliberate act of social terrorism in the society, and saying that, well, it's the government people who are fetching out gold and foreign currency. Well, that can be investigated. If it cannot be established that that was so, and the airport authorities made a statement and said, no such plane left here. We didn't have a plane leave for Barbados, we had a plane leave for Suriname. So that it was a flagrant attempt at destabilizing the country, creating confusion, and therefore instability. So right now, our job as the government of Guyana is to ensure that there is stability, to ensure that there is respect for the Constitution. We are obeying the Constitution, and if we have to wait to see how the Constitution is determined, then we will wait, because we have an interest in obeying the Constitution, not to violate the Constitution. And that's what we are doing at the present time.
Yeah, I'm not
Thank you.
saying you so
Last
it's real
question?
quick. Could you say if prior to the vote, if government MPs were privy to that information that a 34 majority was needed as opposed to a 33, were government MPs made aware of that before heading into the vote? And quickly for Minister Harmon, the opposition leader has said already that he has engaged the diplomatic community, ambassadors, high commissioners, and after the stipulated time when elections are supposed to be held, the opposition will not recognize the government as a legitimate government, and so any deal that would come after that date, they would not recognize. For want of a better word, could you say if there are any plans by the government to cushion this to ensure Guyana doesn't, say, lose out in a way within that time frame?
Well, let me deal with the first question, and I'll ask Minister State to deal with the second question, whether we were aware of the requirement 34. I don't think it's so much whether anyone in the government was aware that you needed 34. It was more important for the mover of the motion to determine whether he knew that he needed 34. And if so, whether he had been recipient of a legal opinion, which we now know was delivered to the chamber of former Attorney General Anin Nanlal on the 11th of September 2014 by a prominent lawyer, Mr. Fraser, delivered the opinion, was contracted to write the opinion. So there is a thing in law and even in doctrines of fairness that if you knew something, you had a right to disclose. If you came to the Parliament, Parliament is a place, they call it, like the House of Equity. They say he who goes to equity comes with clean hands. So if you are going to the Parliament and ask that the Parliament should pass a resolution which you're moving, you had an obligation to make disclosure that I'm bringing this resolution before the Parliament, but I know that it requires 34 members, and I'm trying as best as I can to persuade some members of the opposition to vote with us, the government to vote with us, because we can't rely on our 32. So for me, it's not so much what the government knew. It is what the opposition knew at the time it tabled that motion.
But PM, could you say for yourself then, not government MPs, if you knew heading into the vote, if you knew that 34 was needed as opposed to 30?
I would have kept smiling.
Yes, sir.
Well, I would have been smiling then and as I'm smiling now.
Well, the question of speaking to foreign embassies here, as you know, we in the government, we briefed the ambassadors and high commissioners here in Guyana with respect to the government's position on these matters. We believe that the ruling of the Speaker today adds clarity to what we have been saying all along. And therefore, a threat by the opposition about recognizing contracts and so on, I think it's quite premature. I think that, that those governments, those representatives of foreign countries, that they will be able to make a proper analysis and a report to their countries, to their home offices, to the governments in their countries. And the question as to whether companies invest in Guyana is a decision which the companies will make. These will be business decisions which these companies make. I believe that Guyana is a safe place to invest. We are a secure destination. And over the last year or 2 years, you'd have seen the number of companies registering here, coming here to do business. And in my view, that business environment has not changed. That security environment has not changed. And in my view, I think that the companies looking at Guyana as a destination for investment, that nothing much has changed except an opposition that is now bent on creating mischief, in my view. That is my statement.